Good morning, everyone. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the case of the State of Michigan versus Jason Massey, 24S-00156.
Tiffany Woods for the people.
Good morning, Your Honor. Michael Vincent on behalf of Jason Massey. Mr. Massey, state your name for the judge.
Jason Massey.
Thank you very much. All right, we're here today for a hearing in this particular matter. I did receive the defendant's brief regarding the issue of whether or not Mr. Massey was under or considered himself in custody or free to leave at the time of this the questioning, and so that's the issue before us today. We have made a record of the issue at the last hearing. Are you ready to proceed, Ms. Woods?
Yes, Judge, and I also filed a response to that.
I did not do that.
I sent it a couple days ago to Heather, 14B court. I CC'd Mr. Vincent on it.
Your Honor, we never got a brief from the prosecutor's office. All we received was a 2-page police report.
Judge, I sent that to I sent it to 14B traffic criminal Heather Ball and Michael at Vincent Legal Services. It was people's response to motions, defendant's motions to dismiss, and it was sent on Wednesday.
All right, I do have my copy, and the reporter indicates that your email address is also in that particular email, Mr. Vincent. So maybe ask your staff to provide it to you. We're going to take about 5 to 10 minutes to take a look at that. I'm just getting my copy as well. So
All right.
give about 5 to 10 minutes. Court be on a brief recess.
Yeah. Okay. Go! Will you hand me my screen box?
Now go.
All right, the court will recall the case of the State of Michigan versus John Massey, 24S-00156.
Tiffany Woods for the people.
Your Honor, Michael Vincent on behalf of Mr. Massey.
Thank you. Mr. Massey, please state your name again.
Jason Massey.
Thank you. All right, we took a moment in order to review the people's response to the defendant's motion to dismiss. Have you had a chance to adequately review that, Mr. Vincent?
Yes, Your Honor.
Mm-hmm.
And I have an objection to that report at the appropriate time.
All right, you may proceed.
The document that I just finished reading cites a lot of what Deputy Roberts had to say. Deputy Roberts never testified, Your Honor. I never had a chance to cross-examine Deputy Roberts. To put that in a motion or memo of law, I believe is inappropriate. I never had an opportunity to cross-examine. What I was doing was going through my notes. He never took the stand. The last thing I remember about the deputy, I asked him to be sequestered, and he was never called, to my best memory, and to all the notes I have. Secondly, there was an investigation going on of a serious charge, particularly in this county, of domestic violence. And even if he did testify, one of the questions I would have asked him is the whole, what were you doing? What were you investigating? What kind of charge? But I've never had a chance to cross-examine Deputy Roberts, and have no way to respond to whatever the prosecutor thinks Deputy Roberts may or may not have said. Also in the report, there is talk about a traffic stop. Typically traffic stops, which I'm well aware of what involves in a run-of-the-mill traffic stop. You ask for a license or registration. Typically people are speeding or going through a stop sign or a red light. And you don't have to read somebody a Miranda to get their driver's license registration. It's a very minor stop. No one's confrontational. You can get a ticket. So this is not a traffic stop. It's not a Terry stop either. And Terry, a 25-year veteran Cleveland detective, noticed two people working outside of a jewelry store minutes before closing. Based on that training experience, he got out of his car and patted one of them down and found a gun. This is not a Terry stop either. This is a full-blown investigation that went on and put in there a minute and a half. This went on a lot longer than a minute and a half.
Well, I think, Mr. Vincent, she's referring to the statements that were made by your client, which she claims were, for the most part, volunteering. And they have a right to stop and see what's going on.
My issue with Deputy Roberts is I never got a chance to cross-examine the man, not once. And I'm frustrated by the idea that in the police report, I think it's at least 2 or 3 pages of what Deputy Roberts did, why he did it, all sorts of information, none of which I can challenge in cross-examination. And I don't think that's right to say, put in a report.
He's present today.
Yes, Judge, I thought that's what we were here to do.
Ms. Woods, 1 second. Go ahead, Mr. Vincent.
My understanding of the Miranda was an issue that was brought up the last minute by the prosecutor.
No, I brought up the Miranda issue.
Well, Your Honor did. And then I responded to that issue. I did respond to whatever was going on with Deputy Roberts because that was never testified to. No issues were raised at the hearing about Deputy Roberts.
Well,
And
he's
for
a
the
part, he's a part of the, it was 2 people there. They're all there. So the question is whether or not that the entirety of that investigation was a violation of anybody's rights. It's not whether it was Trooper Verant or Deputy Roberts. It's the 2 of them together make up the entirety of the circumstances. But as to your issue of what was put into the memo, I mean, it wasn't written in a fashion where she said that she believes that the trooper will testify to X, which is how it should have been written. But people write that way, put what they believe the officer is going to testify to all the time. That's not abnormal.
What is being referred to in the memo, Your Honor, is the deputy's investigation, the deputy's police report, which we did receive. By the way, we never got the email on this motion or memo of law from the prosecutor. I don't know why, but we didn't get it. But my objection to this is any reference to the deputy, any reference to what he did or didn't do. I was unable to question the deputy, and he's referred to almost half the motion. I had no opportunity to challenge him. I had no opportunity at all. I would have asked him.
He's here right now.
And Judge, I thought that's why we were here today when we had our last hearing, when you brought up the custodial interrogation issue. I had mentioned that that was never litigated at our last evidentiary hearing and that asked for an opportunity to litigate those issues. Then we set this for an evidentiary hearing today. I have both of my officers present because I was under the impression that they would be testifying today. It would be a brief testimony. Like I said, the statements were made within a minute or so into the body cam. I'm prepared to have them testify. I'm prepared to play the portions of the body cam where Mr. Massey does make these statements, and then to have the court, then decide as to whether this was a custodial interrogation. And I wrote my memo in a response to Mr. Vincent asking for the court to dismiss the case outright. I always respond to memos written or motions written by the defense, and I believe that's why I thought we were here today. That's why my officers are here.
I understand.
Your Honor, may I respond?
Certainly.
On the last hearing, I asked for the deputy to be sequestered. Obviously, at this point, he hasn't been sequestered in the sense that he's been contacted by the prosecutor, and there's a report even made. I think about a week ago, by the deputy regarding 911 calls. I want him sequestered. Obviously, at this point, he's not sequestered anymore. He's here in court. He's heard the arguments. He's heard the testimony. He's had a chance to talk with the prosecutor after our hearing. And I specifically asked for sequestration. And I remember the deputy getting up and going out in the hallway. So now today, after all this is done, he knows what went on. He's talked to the prosecutor. He's had an opportunity to review anything that I did at the last hearing. The purpose of sequestration is to have a witness to be fresh, to not somebody who got to listen to prior testimony, prior information, then come in with that knowledge when he's cross-examined by the attorney. He was sequestered. At this point, to bring him into this case, it's too late. That could have been done. That could have been done on the day of our hearing. He was in the hallway. All prosecutor had to do was call him in, and she didn't. But now we're at this point, it's too late. It's too late to bring his testimony or any information he may or may not have. And I'm totally objecting to anything he may have to say today because it violates the sequestration rule.
Judge, sequestration has to do with testimony. There is no testimony going on right now. Deputy Roberts was not present when Trooper Verant testified the first time. He was outside in the hallway. And to say that we are now breaking sequestration rules when there's absolutely no testimony from any officers going on at this moment, that would break any of those rules, Judge.
I agree with the prosecutor.
The first 2 or 3 pages of the report that I received from the prosecutor, basically, it's a violation of sequestration in the sense that whatever he was going to say on that day and time is in the report. But he never had an opportunity to testify, and I had no opportunity to cross-examine him, which I would have done.
Mr. Vincent, you know what? You can't just shift it to Ms. Woods. You were here too. If you wanted to question him that day, you could have done that too. The issue is that the way that your motion was originally written addressed one issue. When I ruled on that issue, another issue arose from that. You can't fault any side for not actually taking testimony on that issue. We're here for that particular issue today. Now, having said that, that's my ruling. Having said that, as far as the statements that Ms. Woods put in her brief, Ms. Woods, were any statements in your brief, statements that are not from the police report itself? Or is there additional discussion that was held with Deputy Roberts that's now placed into your brief?
Judge, those statements were statements that I watched the body cam. They're statements that were said on the body cam. That's where I got those statements, because I presumed that after they would testify today that I would admit their body cam, and that's where I got those statements. And those body cams, Mr. Vincent has those body cams. He has those exact statements that were made. I didn't get those statements from the officer. I got them from what's on the body cam.
And has Deputy Roberts reviewed your brief?
No, Judge. And you can ask, neither Verant or Roberts have reviewed those briefs, the brief that I wrote.
May I reply, Your Honor?
Certainly.
It's not my job to call witnesses for the prosecution. I had no reason to call the deputy. The only issue was Trooper Verant. The deputy never testified. If I had called a prosecution witness for me, my client, I believe that'd be malpractice.
And Judge, the reason why we were there at the last hearing had to do with the field sobriety test. He wanted that thrown out. There was no reason to call Deputy Roberts. He didn't do the field sobriety test. When the custodial interrogation,
Ms. Woods, I appreciate everything you're arguing. I'm fully aware of the issue and I've already ruled on that issue anyway. So, all right, either we're taking testimony today or I'm just going to make my ruling on the briefs. What do you want to do, Mr. Vincent?
In my opinion, having the deputy testify would be going along with the prosecutor's position. My position is he should not be allowed to testify on this.
All right, well, then I'll make my ruling on the briefs. I've said
Thank you.
where I am now. So if you want me to make my ruling on the briefs, then I will do that.
Yes.
Okay. If we're making a ruling on the briefs, any further argument on the briefs? Because if you think that's in your client's favor, you go ahead and you do that.
If I called the deputy in, then I'm agreeing that my sequestration request
You're not. You're
was
actually.
meaningless.
I made a ruling, and
I
you
know, but I'm telling from my standpoint.
Okay.
That's what I'm talking about. I'm not arguing with the judge, Your Honor. I'm just staying from my viewpoint.
And I've already made a ruling, so you have to operate under the ruling. And if you choose to not, then I make a ruling on the briefs.
Well, let's hear from the deputy then. Let's have the deputy sworn in.
All right. Trooper Verant, we're going to place you back into the waiting room because at this point we're asking questions about a different part of the situation out there. So we're going to place you back in the waiting room.
Got it.
Thank you.
Your Honor, may I address the part briefly?
You may.
The fact that I am agreeing to cross-examine the deputy, does that mean that I don't give up my argument by the sequestration? I want to preserve that argument.
It is preserved.
Thank you.
Before you both start questioning the deputy, I have, what I think the issue here is a little bit different than how it's been framed already today, first of all. So let me say that, so we don't have this issue going forward. And maybe you guys can you put Deputy Roberts back into the waiting room for a second while I ask them some questions? Because I'm going to get into the details at this point. I think the issue is more than just whether they had the right to interrogate him on the street or whether they did. It was a whole separate issue. But the question becomes, let's say that he made the statements as was written in the prosecutor's brief, and those statements come in. So at that point, do you both agree then that they get to do field sobriety tests? Let's say those statements come in. That's my hypothetical question.
Your Honor, could you repeat that, please?
Let's say everything that let's say the testimony comes out just as Ms. Woods wrote it in her brief. And I rule that it was not a custodial interrogation at that point. The question becomes, was he free to leave then or not? Or did he have to be read his Miranda rights before they made him take the field sobriety test, in my mind?
and Judge, that's why I believe we're here today. And I believe he was not in custody. There was not a custodial interrogation at that time when he made the statements that he was driving that vehicle.
No, you're not hearing my question. Let's say he wasn't in custody at that time. Is he in custody when they start to make him take tests?
Well, I didn't print the case law, but I did read some case law on that they say that it wouldn't matter if he was in custody or not during field sobriety tests because that has to do with movement. And I don't have the exact language, but there is case law on that where whether they're considered in custody, even if they're considered in custody at that point, they're doing tests. So it has to do with movement.
That's if he's driving. That's not if you just stop somebody on the side of the road who wasn't driving.
What do you mean? I guess I'm a little confused.
Well, if you stop someone on the side of the road and they're driving, you have a right to do that. That's the exception. But this doesn't fall within that exception. So how do you get to having him do field sobriety tests? Why don't, and this is my question, isn't there a requirement that if in this particular circumstance, which I ruled it is this particular circumstance, he then needs to be advised that he's under arrest and he has a right to take these tests or not take these tests?
He and that happens, Judge. That when does the field sobriety test, but the field sobriety tests don't happen until there's reasonable suspicion that he's been drinking and he's been driving. When he made those comments to the officer, then the officer now is developing reasonable suspicion that he was under the influence when he was driving, and then he's asked to take the field sobriety test.
I understand they asked him to take the test. You still haven't addressed my issue.
I guess I'm confused as to, because what we're here today for is what I thought we were here today for is the comments that he made about driving that vehicle.
I never said that. I never said that. That's how you defined it as to the comments. So I never said that that was the only issue before this court. What I said was suppression can occur if his rights were violated under Miranda. And I didn't say as to statements only. I said suppression can occur. So even if I ruled that his statements come in, I don't know how you personally get to the fact that his field sobriety tests come in or his results from any of that, if there's a violation of Miranda. And I'm not saying there is yet. What I am saying is, how do you get to that?
Judge, if you're going to rule that he was in custody, there's case law out there that says that field sobriety tests are not akin to being questioned. I mean, it's on a different level.
So that's when the person is driving. That is true. It's an exception. That is not true under these circumstances, Ms. Woods.
Judge, from what I guess I'm a little bit confused by what you're saying, but they can develop reasonable suspicion.
Yes, they can. And if they arrest him, they have to read him his rights. In this scenario, because he's not driving, the exception for field sobriety is when people are driving.
Well, he admitted he was driving.
When they see him driving, they stop. It's a stop. Okay, thank you. Mr. Vincent, do you have anything you want to add?
I think Your Honor has touched on the issue exactly how I feel about this case. This is a highly unusual set of facts. This is not a typical traffic stop on the roadway. The officer asks the person to get out and do a field test. This is not what we have here. What we have here is starting with a serious possible criminal charge of domestic violence or more, some type of assault or crime, excuse me, that morphed into this trooper starting an investigation without reading his Miranda. You didn't see him driving. He wasn't in the car. The car wasn't running. None of the typical street stops for drunk driving apply in this case. He should have read him his Miranda, in my opinion, before anything got going. And he clearly wasn't free to leave.
All right, let's take this.
I said four. There was four. Actually, I counted wrong. I think there's 5 or 6 officers there. Almost a police convention.
Right.
And they all arrive after Mr. Vincent, after the remarks are made. So I guess the court needs to decide if the court's going to decide that he's in custody, at what point is he in custody? Because I don't believe that when he made those comments to the police that he was in custody. If it ends up being developed that he was in custody at some point, it wasn't at that point.
Anything else, Mr. Vincent, before we bring the deputy back in?
I believe when the deputy arrived that this was a custodial situation.
I understand your argument.
And it went and I totally agree with the court's statement. that I feel if he's going to investigate something, he's got him right in front of him. I sent a picture. As a matter of fact, there was two state troopers, one trooper Verant, another young troopers in the picture. So he was there. Cops were everywhere. There was at least two officers to begin with, and this morphed into an investigation that had nothing to do with the traffic stop. Nothing at all to do with the traffic stop.
All right, thank you. Let's bring the deputy back in. All right, Deputy Roberts, you are under oath, and it is your witness, Ms. Woods.
Thank you, Judge. Good morning, Deputy Roberts. Could you please state your name again for the record?
Deputy Greg Roberts,
And where are you currently employed?
Washtenaw County Sheriff's Office,
And in what capacity?
as a deputy canine handler.
Okay. And were you employed with and working in that capacity on March 17th of 2024?
Yes,
And were you involved in an investigation involving Jason Massey?
yes.
Okay. And where did that investigation take place?
It was westbound I-94, just before or at the Michigan exit.
And is that a public roadway?
Yes,
Okay. And what did you observe? First of all, you were driving in that area. Isn't that around that area?
yes, I was driving by.
Okay. And then did you observe something?
Yes,
What did you observe?
I observed a newer Ford Bronco parked on the side of the road. I also observed two subjects rolling around on the ground, off to the side of the vehicle in the ditch near the wood line.
Okay. And is this before you got any calls from dispatch about what was going on?
Yes, yes.
Okay. So once you observed this behavior, what did you do next?
I notified dispatch that I would be going back to the area to investigate it. And at that point, Metro Dispatch advised that they were receiving multiple calls from passerbys, stating a variety of different things regarding a possible incident involving the two.
Okay. And did you approach that scene?
Yes.
And when you approached the scene, where did you park your vehicle?
Facing the vehicle, the suspect's vehicle or the individual's vehicle.
Okay. And approximately how far away did you park your vehicle from the defendant's vehicle?
I would say roughly 25 feet.
Okay. Were you in any way blocking the defendant's vehicle?
Well, if he drove straight, he would have hit my vehicle, but he had an option to go around. There was the ability to go around my vehicle.
Right. So you didn't pull in head on blocking his vehicle. You pulled in
Objection,
kind of to the
leading
side.
question. Objection, leading question, Your Honor.
Did Judge, I'll strike that. So when you pulled in, did you pull in head on?
Yes.
Okay. So when you pulled in to your vehicle, were you in any way blocking the defendant's vehicle?
The vehicle had the ability to go around my vehicle. I wouldn't say that it was blocking the vehicle from being operable.
Okay. And so whenever you pulled your vehicle in, what did you do?
I exited my vehicle and made contact with a male and a female at the passenger side door.
And then when you made contact with the male and the female, what did you do next?
I asked the male to walk towards the front of the vehicle
And why did you do this?
to separate the two individuals.
And why did you want to separate the two individuals?
Because preliminary information at the beginning, it was stated there was some sort of assault that was occurring, potentially.
Okay. So what did you do after you separated them?
I spoke with the male subject.
And what did you ask him?
I asked him.
I'm going to object to anything he said at this point, Your Honor. The deputy just said he was investigating an assault. I just finished saying that. There's
You
two
got-
people rolling around on the ground, gets out, deputy gets out of his car or by the car, pulls up to them, separates them. It begins an investigation for an assault. Should have read his Miranda then, when he starts questioning him.
Judge,
An ample opportunity to read the Miranda. He separated them. One is several feet away from the other. He starts talking to Mr. Massey, investigating a crime, investigating an assault. Minimally, a domestic violence assault. Could be more, but he's investigating an assault. Never read him his Miranda.
Judge, Miranda would not be in, he was not even in custody at this time. This is a preliminary investigation. Officers have the right to come on a scene when they believe there may be a probable cause that criminal behavior is afoot. They don't have to Mirandize. Mr. Vincent makes it sound like every single time an officer comes into contact with someone that they have to immediately Mirandize them, and that's not the law.
I did not say that, Your Honor. I did
Judge,
not say
they
that.
have,
I did. Please.
I'm
let me
speaking.
finish.
Can I please make my argument? That
sorry.
from what we have here is we have an officer. First of all, he didn't pull the vehicle over. The vehicle was already pulled over. He has a right to now do a preliminary investigation. They're not in custody. There's nothing here that shows that he was seized at this time. The officer has a right to ask investigatory questions. He's not in custody. Miranda is not necessary at this point, Judge.
Thank you. I agree with the prosecution that the Miranda had not been required at that time. You may proceed.
And then when the defendant approached you, did he make any comments to you without you asking him anything?
I believe so. I would have to review body cam for the exact statement.
So you were wearing your body cam during this incident?
Yes.
Judge, I'd ask to share my screen to put the body cam on video.
Thank you. You may.
So where you guys live?
But I can't make it out.
So you pull over to the side of the road because you had why was she all on the ground? People are calling by saying, "That's right, just stay over there by the car and I'll talk to you in a second." That's what I'm talking. So that's okay. Get back in the truck, however. It's like I can't. I'm not. I'm so here. I'm right here. I'm right here. Stand right here by the car.
I can't make.
Okay, don't worry about it. What's your first name? Jason Massey. Okay, so for you all. What's your birthday, Jason? 4/28. So be it. Your phone number? 9694439. Say that again. 9443930. Talk to you.
So, Judge, that's where he basically said he was driving. The officer asked him again.
Objection, Your Honor. Am I?
Yeah.
What's your objection, Mr. Vincent?
The prosecutor's testifying as to what is on the tape and testifying as to what one of her witnesses may or may not have said.
Judge, I'll strike that. So Deputy Roberts, at this point, it seems, you asked for the defendant's ID, is that correct?
Yes.
And when he said from the video, what did he tell
I'm
you?
gonna,
Or what did he tell you after you asked for the ID?
That it was in the car.
Okay. And did you have him go back and get that ID?
No.
Okay. And then what did you do after you told him you didn't want to see the ID?
I asked him verbally for his name and birth date and phone number.
Okay. And then after he gave you that information, what did you do?
That is when the trooper arrived and I went and spoke with the female.
Okay. And is that the end of your interaction with the defendant?
From the point that you asked about the ID, yes, but there was obviously, I'm not sure if the video was.
Objection, Your Honor. He's going off, not answering the question. He's narrating.
So after you spoke to Mr. Massey, then where did you go?
To speak with the female.
Okay. And did you have anything to do with the investigation for the DUI investigation after that?
No.
Judge, I have no further questions.
Thank you. Mr. Vincent, any questions from you?
No questions.
Thank you. May this trooper be excused.
Yes, Judge.
Yes, Your Honor.
Thank you.
Thank you. I mean, Deputy, I'm sorry. Are you any other witnesses today, Ms. Woods?
Yes, Judge. I also have Trooper Verant.
Please bring in Trooper Verant from the from the waiting room. Thank you. You may proceed, Ms. Woods.
Could you please state your name again for the record?
Trooper Zachary Verant.
Okay. And Trooper Verant, where are you employed?
Currently, I'm employed at the Michigan State Police Metro South Post. At the time of this incident, I was employed at the Brighton Post.
I'm sorry, could you please repeat that?
No, that was me.
Yep, I'm currently employed by the Michigan State Police.
And were you employed, in what capacity are you employed with Michigan State Police?
I'm assigned to road patrol.
Okay. And were you working in that capacity on March 17th of 2024?
Yes.
Okay. And were you involved in an investigation involving Mr. Massey?
Yes.
Okay. And how did you get involved in that investigation?
Yep. So on that date and time, I was dispatched to an unknown crash on westbound I-94 near Michigan Avenue. Callers were advising that there was a blue vehicle, a blue Bronco, pulled over on the right side of the road.
I'm going to object to hearsay, Your Honor.
Response?
Where?
Ms. Woods, are you rephrasing? Can you let me know what you're?
Yes, Judge, I'm going to rephrase that question. So when you were at that investigation, did you arrive at that investigation?
I did.
What was the location of that investigation?
It was westbound I-94 near Michigan Avenue.
Is that considered a public roadway?
Yes.
What did you observe when you came to that investigation?
When I arrived on scene, I observed Deputy Roberts was already on scene. There was a blue Ford Bronco that was pulled over onto the grass off the right shoulder of the freeway near the exit ramp. I observed the defendant, Mr. Massey, was leaning on the front of his vehicle. His girlfriend was standing off to the right side of the vehicle.
Okay, and when you pulled in your vehicle, where did you pull your vehicle in?
I parked on the right shoulder, probably about 20 yards or so behind where the defendant was parked off to the right side in the grass.
Did you block in the defendant's vehicle?
No.
Okay. And did you observe where Deputy Roberts' vehicle was parked?
He was parked on the right shoulder, slightly in front of where the defendant's vehicle was.
Was, from your observation, did it appear that Deputy Roberts' vehicle was blocking in the defendant's vehicle?
No.
Okay. So, and were there any other officers on scene when you arrived other than Deputy Roberts?
No.
Okay. So what did you do when you exited your vehicle?
I went up and I approached the defendant and I asked him what happened.
Okay. And what did he tell you?
He told me that they were driving down the road and his girlfriend had to use the restroom. So he stopped to pull over and allow her to get out of the vehicle and use the restroom.
Okay.
Trying to get her back in the vehicle.
Okay. And at what point did you suspect that the defendant was drinking?
Going to object to the question, Your Honor. Prosecutor's assuming something that has not been established yet.
Okay, I will strike that and ask. Did you observe anything when you were speaking with the defendant?
So initially, when I first approached him, I did not. I had him step back towards my patrol car. While I was speaking with him, it was at that point that I detected the odor of intoxicants emanating from his person, and I noticed that his speech was slurred.
What did you do after you noted signs of intoxication?
So after that, I went in back to my patrol car, ran the information for the defendant and his girlfriend. I exited my patrol car. At that time, I began performing field sobriety tests.
Okay. And were you wearing your body-worn camera?
I was.
Okay. Judge, I'm going to pull that up and share my screen. May I have permission?
Any objection?
No. I mean, it is what it is.
Right, thank you.
We pulled over, down the street, we get out of the truck, and I was told there that no problem. I live with her, like our both IDs that have the same address.
What is her relationship with you? Is it going to her girlfriend?
Yeah, I live with her, her house.
Okay. Do you have your ID on you?
It's in the truck.
Is it the trunk or is it that?
We did.
In the middle, you want to go grab it for me? Do you have any weapons or anything inside the trunk at all? Okay, let's go grab that ID for me. We'll get it sorted out here in a minute.
I can't. It's all scrambled, right? I think, I'm old and they can't hear. Our sound is on.
Come on, go right in front of my car. Where are you guys headed to right now? Slade? Where you guys live? Okay. Where are you guys coming from? Detroit? So you stopped to let her use the restroom?
She said she couldn't make it to the exit. We're right there. Yeah. So okay, I'll pull over. And then she fell over because she get us off and I was getting stuck in everything. We live together. We have dogs.
How long you been together for?
10 years.
10 years?
Yeah. Okay.
All right.
Yeah.
What are you guys doing down in Detroit?
We just got to the bank at the meeting station.
Okay.
We had a birthday party and so glad that we just.
How much has she had to drink today?
So I was like, get up, get it out, get it out.
How about you? How much have you had to drink? A little bit. How much? A little bit.
Probably
Too much?
Can you understand him? No.
Your car? Okay, just have a seat on the first part for a second, okay?
And were there any additions, deletions, any changes to this video? To Verant?
No.
And at some point, did you have the defendant do the field sobriety tests?
Yes.
Okay. And after he did the field sobriety tests, what did you note?
During the field sobriety test, I noted multiple indicators of intoxication. At what point I administered a PBT after that. And at that point, he was placed under arrest for operating while intoxicated.
Okay. And what were do you recall the results of the breath test?
The PBT was a 0.137.
You're not going to object to any, we've had this testimony already.
I agree. So I'll stop now, Judge. I agree. I don't want to go into all of we've already litigated that issue, so.
I don't want to start asking questions about the PBT and observation and all that. We did all that already.
She agrees with you, Mr. Vincent.
Oh, thank you.
All right. Your witness, are you done with your questioning for the trooper?
Yes, Judge.
Your witness, Mr. Vincent.
Well, Your Honor, I'd like to create a record. I could not understand. I heard some of what the trooper said, but as far as my client, I could not understand what was being said. It was garbled. I did hear some of what the trooper said. So I don't know what to ask him based on what I just heard on the video. I could not understand. In fact, I didn't hear my client most of the time, and when I did, it was garbled. And trooper, you didn't do anything to this video, correct?
Correct.
Okay. And you stored it in a normal way. I mean, you didn't garble it up deliberately or anything else like that, correct?
Everything is automatic for us. We don't have any part of storing the videos. It uploads automatically.
Yeah. All right. When you arrest, when you stop people and you have a suspicion that they may be intoxicated while they're driving, I'm not asking this particular case. I'm asking, what is your procedure? If you get somebody out and the subject decides to simply walk away, what would you do? You wouldn't let them walk away. Is that right?
I mean, it depends on the exact situation.
If you do, I understand. Let me ask the question again. If you are suspicious that a person that was driving a vehicle was intoxicated and you began field tests and he told you, I'm walking away, I don't want to talk to you, goodbye, what would you do? You would grab him and not let it, would you agree with me? You would not let him leave?
Correct.
Thank you. No further questions, Your Honor.
Thank you. Any further questions?
Not from this witness, Judge.
All right, thank you. You may be excused, Trooper Verant. Thank you.
Thank you, Trooper.
Yep. Have a nice day.
You too. Any further witnesses, Ms. Wood?
Not from the people, Judge.
All right, any witnesses from you? Mr.
No, Your Honor. No, Your Honor.
All right, argument.
Yes, Judge. From what we saw in the video, there was no seizure. There was essentially no traffic stop. This isn't a typical, where the police seize the vehicle or anything like that. This is more akin of what I would believe would be a Terry stop, Judge. And officers do have a right during, a Terry stop is narrowly drawn exception. Officers may stop a person upon reasonable suspicion that criminal activity is afoot. An officer is able to ask the detainee, which what he is at this point is just being detained, a moderate number of questions to determine his identity and to try to obtain information confirming or dispelling the officer's suspicions, which is what we have here, Judge. When Officer Roberts arrived, he had a reasonable suspicion from what he observed that there was some sort of criminal activity afoot, which he believed at that point was possibly some sort of an assault. He got Mr. Massey's identification. Mr. Massey gave him information that there was nothing going on, that he had to pull over. He had to pull over the vehicle because his girlfriend had to pee and she couldn't wait. The detainee is not obligated to respond, but if he does, he can. The nature of the Terry stop is detainee, he's not entitled to Miranda rights at that point because technically he's not in custody. Now, if the judge, then let's take a look at when Trooper Verant arrives. Same thing. He has an opportunity to ask questions, determine what's going on, get identifying information. And then if there's probable cause to go forward with an investigation and eventual arrest, they can do that. Now we're here to look at custody, Judge. A custodial interrogation has to do with whether the defendant, or actually, no, the standard is whether a reasonable person in this circumstance would feel free to leave. And there is no bright line rule. The courts look at a lot of different factors as to whether a reasonable person would feel free to leave. And several factors that the courts have taken into consideration is the purpose of the questioning, whether the place of the questioning was hostile or coercive, the length of the questioning, where the questioning took place, whether the defendant whether the suspect was told that his questioning was voluntary, or if he was free to leave, or whether they restrained his movement, or whether they told him he was not free to leave. So, let's take a look at this case, Judge. This questioning took place outside, and there is case law that says that having an officer question a suspect outside is not coercive and it's not hostile. It has a lot to do with the fact that it was on a public roadway, it was during the day, and there's traffic. All of those factors go into the fact that this is not a hostile and coercive environment. This is not behind closed doors. He's not in a police car. He's not handcuffed. Another thing that the courts look at is whether the defendant is free to leave is, can he move or drive away? He can, Judge. His vehicle was not blocked in, as you can see from the body cam video, especially from Trooper Verant's body cam. When he walks up in the video, you can clearly see that Mr. Massey would have been able to pull straight away and get on the roadway. He was not blocked in. Those officers did not box his vehicle.
Without his license?
I'm sorry?
Without his license.
Well, let's get to that, Judge. So when Deputy Roberts was questioning him, he says,
Robert, it said Verant.
Well, I think that both of these, I think that I should analyze both of them because
you should analyze what I'm asking you about, which is Verant.
So Verant does at some point say, do you have your license? He gives him his license. As he's questioning him, it's not until after the questioning is done that he actually physically takes his license and gets into his police car and then runs his information. That's after all the questions are done.
He has his license the whole time.
Not at first, he doesn't.
He asks him to give him his license. He goes into the car. He gets his license. He hands it to the trooper. The trooper then takes him back to the vehicle while he has his license in hands. Ms. Woods, I watched the video.
Right, and that's something you look at, but in traffic stops all the time, Judge, where they're not considered to be in a custodial interrogation, officers take
that. We're talking about this case. This is not.
Well, so, I mean, we're basing, when I read other case law, they say that there are a bunch of factors, and in traffic stops, that it's very common for the officer to take someone's license and run their license and registration because the officer is going to eventually give that license back. It's not like Trooper Verant took his license and left with the license or refused to give his license back to him, Judge. That never happened.
Right,
and it's very common for officers when they're in a traffic stop to take someone's license, run the information.
We keep talking about hypotheticals that we're not talking about. And so you can keep doing that. It doesn't confuse me in case you think it does.
I'm not trying to confuse you, Judge. I'm just trying to relay what I've read in case law.
Not about this particular situation, as I've said like 5 times.
Okay, so he did take his license, Judge, and he did run his information and you don't see in that video, but he does get his license back. Officers, others things that they look at is how many officers were there. At that point in time, when Officer Roberts was there, he was the only officer. There was no other officers there. That was a very, very brief questioning that only lasted for, I believe, about a minute and a half. There's no weapons were drawn. There's no threats. And then when Trooper Verant arrives, that's only the second officer. And again, there's no other officers during that time period that are there, essentially a show of force with weapons that would make the defendant believe that he was not free to leave. Whenever he was made those remarks, those admissions to both of those officers.
There's no admission for the deputy.
The defendant was never threatened. He was never removed from the scene. He was never placed in a police car. There was no physical touching. There was no intimidating language. They never restrained his movement. All of the things that you would find when someone is in custody didn't happen in this case, Judge. So whenever Mr. Massey made these admissions to both Deputy Roberts and Trooper Verant,
I'm going to object Your Honor, I'm going to object at this point about deputy.
I'm trying to make my argument.
I'm sorry, but you keep mentioning what he said to Deputy Roberts. There was nothing on the tape.
There is there is the remarks that he made. We all listened to it. It was in evidence. He did make remarks that he had to pull over. Those were remarks that were made. He told Deputy Roberts that he had to pull the vehicle over. At the time that these
Your Honor, I
remarks were
thought
made,
Your Honor
Judge,
made a ruling that's about Trooper Verant. Now we're into Deputy Roberts. I am frankly confused.
I did make a ruling regarding
Yeah.
Trooper Verant. I asked her questions. So let her finish her arguments, and then
All
you
right.
can argue about what you think. Please let me finish making my ruling. You can argue.
my whole point, Judge, is that at the time that Mr. Massey,
my ruling, please.
oh, I thought you said to let me finish.
No, I did. And then you interrupted as I was finishing my ruling. And I said, for you to let me finish my ruling. And then you interrupted me again. So,
I didn't. Sorry, Judge. I wasn't aware that I interrupted you. So go on.
Mr. Vincent, any arguments that you have regarding what statements she's making, you can make them during your argument. I'm going to need the two of you to stop interrupting each other and arguing over each other. The recorder cannot distinguish who's saying what when that happens. Ms. Woods, please sum up your arguments, please.
Yes, Judge. My point being is when Mr. Massey made these voluntary admissions to both the deputy and the trooper, he was not in custody. There was no custodial interrogation that was happening at that time. Therefore, Miranda would not have been necessary at the time that Mr. Massey made those admissions to either Deputy Roberts or Trooper Verant.
Thank you.
Thank you.
Mr. Vincent.
Yes. This is not a traffic stop. This is not a Terry type of stop. This was something very unusual, different set of facts from a normal drunk driving investigation. We started with some type of assault investigation and morphed into an investigation regarding driving while intoxicated. the only exceptions to making an arrest on a 93-day misdemeanor is if there was an accident or probable cause. There simply has been no probable cause provided to this court. And the only thing that been relied on is some type of statement he made. I have argued in my memo of law, I'm arguing now that, and I'll use Trooper Verant's words, what would happen, to my question, what would happen if before everything started going, if he tried to leave? And he would have been, the trooper clearly stated he would have been stopped. He wasn't free to leave. If he's not free to leave, you got to read him as Miranda. I cited a case, Villa versus Gonzalez. Similar situation. Guy was on his front porch and an investigation went on. And I do agree that initially there was 2 officers there, but I provided a photo of another state trooper there right around the same time, another deputy. There was at least 5 to 6 officers showing up periodically. He was not free to leave. It's a custodial situation. Whatever he said has to be thrown out, and there's no probable cause for an arrest. And by the way, I'm sorry I interrupted. I should not do that. Interrupt the prosecutor.
Thank you. All right. In this particular situation, I've listened to Deputy Roberts and Trooper Verant's testimony. I've watched the video. And I have to acknowledge that some pieces of it were garbled and I couldn't make out what everyone was saying. My analysis of this, though, relies on more what the officers were saying, and the 2 of you can figure out what was said at what point from the defendant by watching a video that shows his statements more clearly. The reality is that the initial stop, I disagree with the defense. I believe it was a Terry stop. I believe they do get to ask questions. Deputy Roberts, when he arrived, did have the ability to ask questions. He saw something going on, people rolling around on the ground. He had the ability to stop and ask questions. Any statement that defendant made to Deputy Roberts is considered a part of a Terry stop. When Trooper Verant arrived, he then had the opportunity to come over and ask the defendant to provide a copy of his license, which he did. And anything that was said to Trooper Verant, prior to the time that he hands him the license is a part of a Terry stop. Once he hands him the license and essentially directs him to the car, to the trooper's car, and is holding on to Mr. Massey's license, it is my ruling that the circumstances at that time, including the way the cars were parked, including the way that the defendant was ordered, directed in some way, shape, or form to go back to the trooper's vehicle. The fact that the trooper had his license at that time, the fact that there were 2 police officers, deputies, troopers on the scene, I believe that no reasonable person would have felt free to leave, and that any statement made once he gets back to the car is considered part of a custodial interrogation. So anything that occurs after that is considered a custodial interrogation. That is what my ruling is. There's no debate from either one of you about it. You can appeal it. You don't like it, that's on you. But that is what my ruling is, and it's up to the 2 of you to determine what was said at what point. And I don't know whether or not the prosecution will be able to proceed or not, but anything after that point is suppressed.
Thank you, Judge. And I will be proceeding with this case. I don't want it to be dismissed based on that. I know because the defense counsel wrote, his motion was for the case to be dismissed.
I understand what you want. The only issue is what was said and whether you have enough evidence to move forward or not. And I can tell you, if you're moving forward on something that you can't prove, I am going to assess costs.
Judge, I have a witness. I have potentially 2 witnesses, but I've got Mr. Massey's passenger that was in the vehicle with him that I can call and have her testify at trial. So I believe, and I also have a 911 caller that also described Mr. Massey in his vehicle driving erratically right before the stop was made. So I believe even if I move forward with just the statements to Officer Roberts, I believe there is enough evidence to go forward with this case.
Or you believe statements to I don't know what the statements say. I don't believe that's when he made the statement that he was drinking too much, but I don't know. I don't even think that's what
I just need to put him behind the wheel, Judge. I mean, the fact that he admits that he's drinking or not doesn't mean anything, because I have blood results.
You don't, because that's suppressed.
What's suppressed?
Why is that not suppressed?
His blood results?
Yeah. Anything that happens after the trooper arrives there is suppressed. I just said that.
Oh, I just thought you said his statements were suppressed.
No, I did not say that.
Got it. Thank you, Judge.
Your Honor, again, this matter should be dismissed. There simply is no, based on Your Honor's ruling, there is no probable cause.
Mr. Vincent?
Yes, Your Honor.
I don't know what was said at what point. I can't even hear it, as I said earlier. So the 2 of you need to figure out what was said and what she actually has. She also is indicating that she has a witness who maybe she wants to proceed with that. I can't dismiss the case if that's what her proofs are. She has witnesses that saw him driving that she's bringing in. I can't dismiss her case. That's not how this works.
But you're suppressing his breath test and his blood test?
Unless you had a court order for that, correct. If you had a court order, that's different, but you can't use a blood test where I just said that everything that comes after that statement is suppressed. I don't know if you got a court order. I'm not looking at that part of the case. That's your case.
All right. Yeah, Judge, I'll have to take a look at it then.
Mr. Vincent? Is there a court order?
There's no court order.
Okay. Well, anything after the fact that he's taken back to the car is suppressed. Any evidence, any statements, all of it is suppressed. Please prepare an order to that effect. The prosecutor just decide whether they're able to proceed or not based on that.
Thank you, Judge.
I will present an order to the court, Your Honor, and to the prosecutor.
Thank you.
Thank you.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let this feeling. I'm sitting up here, I'm the one that needs a drink.